Excellencies and distinguished representatives, malo lau malia hoiki mokainga kotoa, sawadee ka, and a very good morning and good evening to you all. Welcome to the high-level Asia-Pacific regional webinar on the draft articles on the protection of persons in the event of disasters. My name is Inau Huifanga Leveni. I'm the Regional Disaster Law Coordinator for the International Federation of Red Cross and Red Crescent Societies, or the IFRC, in Asia Pacific. I'm based in Bangkok and I have the pleasure of being your moderator for this webinar. If you're hearing about the draft articles for the first time, or perhaps you're a little bit unsure of what they are, then I'm happy to say that you're in the right place, because the purpose of this webinar is to share information on the draft articles, what they are and what they could potentially mean, to give an overview of the ongoing diplomatic process at the United Nations General Assembly, and of course to share perspectives on the relevance of adopting a new global framework for reference in the sector and ways that stakeholders may support the process. And to help us do this, we have quite a distinguished lineup of speakers who will be sharing their thoughts and insights on the draft articles from their various vantage points as different stakeholders currently involved in this process. This webinar will start with an overview of the draft articles, followed by our panelists' perspectives, after which we'll have a question and answer session, and then I'll wrap up with some reflections. And you'll be able to find links to our speaker bios and also the webinar agenda in the chat. So without further ado, I have the pleasure of welcoming our first speaker, His Excellency Ambassador Antonio Lagdamel, who is the permanent representative of the Philippines to the United Nations in New York. He is also the chair of the working group on the draft articles on the protection of persons in the event of disasters, or PPED. And this working group sits under the 6th committee, which is the committee that deals with the legal issues in the General Assembly. The ambassador will be giving us an overview of the draft articles and the ongoing process through the UN system. So over to the ambassador.
Excellencies, colleagues, at the outset, I wish to thank the International Federation of the Red Cross for this important regional initiative and for working closely with the missions of the Philippines and Thailand in developing the concept for this webinar. Last year, I had the honor of being given the responsibility by the 6th Committee of the General Assembly, led by Ambassador Surya Chindawongse of Thailand, to chair the working group mandated to examine the draft articles on the protection of persons in the event of disasters, or PPED, and to consider the International Law Commission's recommendation for the elaboration of a convention on the basis of the draft articles, or for any other potential course of action. I take responsibility for steering the working group and intercessionally have led and supported efforts to generate awareness on the draft articles. I thank the IFRC for this timely webinar. To provide an overview of the draft articles on the protection of persons in the event of disasters, I wish to begin by placing emphasis on the need for the draft articles. This year, we mark the 20th year of the 2004 Indian Ocean tsunami. The draft articles are a response to the devastation in the wake of this tsunami, conceived to fill critical gaps in international disaster response laws, establish clearer obligations, enhance coordination, and uphold the dignity and rights of affected persons. The draft articles are of value because of the increasing frequency and severity of disasters. Many states remain unprepared for disasters, and the draft articles could help provide certainty about what governments can expect from other governments and humanitarian organizations following a disaster, relieving the domestic authorities and protecting lives. In the absence of a clear and comprehensive legal framework to regulate disasters, there are views that a universal hard law instrument on the protection of persons in the event of disasters could serve to consolidate states' obligations and facilitate international cooperation. The draft articles place an emphasis on the need to respect state sovereignty and recognize the primary role of the affected state in providing assistance. It also aims to facilitate the adequate and effective response to disasters and reduction of the risk of disasters so as to meet the essential needs of persons concerned with full respect for their rights. It also highlights upholding human dignity, human rights, especially the right to life, and humanitarian principles. It stresses the importance of disaster risk reduction to prevent, mitigate, and prepare for disasters. It will highlight also the importance of international cooperation in disaster response, balanced with respect for the sovereignty and non-interference in the internal affairs of the states. It also mentions forms of cooperation, which includes humanitarian assistance, coordination of international relief actions, and sharing resources. It provides that external assistance must be provided with the consent of the affected state, which will always retain the right to control and coordinate such assistance. It provides the conditions under which affected states are expected to seek external assistance, emphasizing the balance between national capacity and international support, and also include the protection for relief personnel and the conditions under which external assistance may be terminated, ensuring respect for the sovereignty and needs of the affected state. The draft articles have the potential of filling the legal lacunae. Stakeholders have identified the current gaps in the existing framework. This could include, for example, the lack of clarity in requesting or accepting international assistance, the absence of a single entity responsible for coordinating international assistance, and defining roles and responsibilities for humanitarian actors. On a practical level, the draft articles could also address issues such as delays and financial burdens caused by customs duties on humanitarian goods and supplies, the absence of priority landing for planes and ships carrying humanitarian groups, lengthy registration processes, and costs for international vehicles, machinery, and IT equipment. Further, it could also provide a solution to the complex and time-consuming visa approval processes for international humanitarian staff, quarantine requirements for people and animals, restrictions on international professionals practicing in a country, strict timeliness and administrative processes for importing medication and medical equipment, and the need for recognition of professional qualifications and quality and accountability standards. These gaps hinder effective and timely response to disasters and the provision of necessary assistance. There is political momentum for the draft articles as a complement to the existing framework. The 2023 political declaration for the midterm review of the Sendai framework on Disaster Risk Reduction calls upon states to, and I quote, ensure that disaster risk governance is supported by legal and regulatory frameworks, policies, and plans at all levels, unquote. On the overview of the diplomatic process, I note that it has taken 20 years for the draft articles to reach their current form and reach the 6th committee. To trace the provenance of the draft articles and survey the diplomatic process, we recall that the Indian Ocean tsunami in 2004 gave impetus to this work. The UN Secretariat started the work that eventually led to the ILC's consideration of this issue. In 2016, the ILC finally adopted the draft articles and recommended the elaboration of a convention on its basis. In 2016, at its 71st session, the UN General Assembly decided to include the draft articles in the provisional agenda of the 73rd session and invited governments to submit comments. In 2018, again, the UNGA retained this item in the provisional agenda of its 75th session. And in 2020, finally, at the 75th session, the UNGA then decided to defer the consideration of the agenda item to the 76th session. A breakthrough finally happened at the 76th session in 2021, when the General Assembly decided, and I quote, to examine the draft articles and to consider further the recommendation of the Commission for the elaboration of a convention by the General Assembly or by an international conference of plenipotentiaries on the basis of the draft articles or any other potential course of action with respect to the draft articles within the framework of a working group of the committee to be convened for 4 full consecutive days at the 78th and 79th session of the Assembly, close quotes. Pursuant to this, at its 78th session in 2023, the 6th Committee established a working group. Last year, the working group held 8 meetings on the 5 thematic clusters, following which I delivered the chair's summary, which was envisioned to assist delegations in continuing the intersessional dialogue on the draft articles in preparation for the final session of the working group this year. Meanwhile, in the interim, there have been intersessional efforts to raise awareness on the draft articles. In April this year, I led a panel discussion on the draft articles with the UN Office for Disaster Risk Reduction and the Asian African Legal Consultative Organization. UN Undersecretary General Miguel de Serpa Suarez headlined the event. We will also spotlight these articles at the forthcoming Asia-Pacific Ministerial Conference on Disaster Risk Reduction, which the Philippines will host soon. Next week, at the sidelines of the high-level political forum, the Philippines, again with UNDRR and the UN OCHA, will host an exhibit on the draft articles on PPED at the UN. Excellencies, colleagues, the fate of the draft articles now rests in the member states' hands. Member states will decide by way of a resolution, and our leaders should take notice of what is at stake. At the 79th session of UNGA this year, the Philippines as chair is committed to deliver concrete outcomes for the working group. I urge active participation of all states in the deliberations of the draft articles in order for the working group to come forward with a report to the 6th Committee, with a view to the committee making recommendations to the General Assembly as to any further action to take in respect of the draft articles. I welcome other decisive action by member states, especially from the Asia-Pacific region, in moving forward with the consideration of the ILC's recommendation. And I look forward to a very robust exchange of views and your cooperation. Thank you very much.
Thank you, Ambassador Lagdemel, for the very comprehensive overview. So now that we have an overview of the draft articles and what they are, and the Ambassador gave quite a thorough analysis of some of the common regulatory barriers that the draft articles hope to address. He also noted in terms of the ongoing diplomatic process that the point that we are at now is around 20 years in the making. And I'm pleased that he ended with a very strong call to action for member states who will be heading into the United Nations General Assembly later this year. So now that we have this foundational background to our discussions, let's now turn to our esteemed group of panelists who are representing various stakeholder interests to hear their perspectives and thoughts on the draft articles. I'm pleased to introduce our first panelist, who is Mrs. Supanvasa Chotikajan Kang, the Director General of the Department of Treaties and Legal Affairs from the Ministry of Foreign Affairs of Thailand, and she will be speaking from the perspective of an Asia-Pacific state. So welcome, Director General Kang. We know that Thailand has been extremely active in its support of the draft articles. Can you share with us what are the primary responsibilities of states under the draft articles in ensuring the protection and well-being of persons who are affected by disasters, and how can states balance these responsibilities with sovereignty concerns? And if I can just sneak in another one in there, how do you view the potential contributions and the practical impacts of adopting a convention in this field?
Hello, everyone. Thank you so much for inviting me to be a part of this very important panel discussion. First of all, I'd like to thank the IFRC for its initiative in organizing this webinar. And as our moderator has introduced herself as she's based in Bangkok, I too am based in Bangkok, but due to the responsibilities of being an international lawyer, I am coming to you here from the wonderful city and very international city of Geneva. So I hope to have some fruitful exchanges through this important discussion today. Before I actually answer the question posed to me, I just wanted to say that this discussion comes at a very timely opportunity for us to really bring forth the issues that are important to humankind, in that the world is now facing even more intense and numerous disasters all across the world due to external factors such as climate change and such as sea level rise, and with the onslaught of the pandemic, for instance. So these are all threats that we must face together. And I believe that the solution lies within trying to reduce the risk and trying to mitigate the effects of such threats. Unfortunately, as an international lawyer, in really looking at the relevant laws that deal with disasters, it seems to me that currently there seems to be a fragmentation of these laws, and there are different developments in different areas of the world. There's yet to be a comprehensive, internationally legally binding instrument covering all phases of disasters. They are piecemeal and they are divergent regulations and procedures, and it requires a uniform development of disaster law. We have instances of such as the Yokohama Strategy, Plan of Action for a Safer World, and of course, the latest one is the Sendai Framework for Disaster Risk Reduction 2015-2030. Of course, these are often called soft law, meaning that they are existing frameworks which are non-binding in nature, and of course, they are not universal in membership. So in our discussion today, we're looking through what is the potential basis in which we can advance a international law that addresses disasters. So the draft articles, which were established through the International Law Commission in 2016, is probably a good starting point in which we can discuss all of these relevant issues. So to answer your question, what is the primary responsibility for states as envisioned under the draft articles? The first issue, I think, most importantly, is the obligation to respect human rights, human dignity, and humanitarian principles. These can be found in Articles 4 to 6. Indeed, these are the core obligations of the convention. It's unfortunate that when we have a disaster in a situation, the human face of that disaster is often not accounted for. We're fixated on the issue of the state, the security of the state, the continuity of the state, and sometimes the most poignant points in a disaster is often the victims of the disaster, and the protection and well-being of persons as they are affected by those disasters is often forgotten. So the draft articles really, in fact, have a standalone article that specifically makes it a duty to respect the human dignity and human rights of people who are affected. The second point is in Articles 7 and 8. This deals with a very important issue, which I think is the highlight of the draft articles themselves. It is the duty to cooperate and specifies the forms of the cooperation that it can take. So I believe that international cooperation is the key element to disaster risk reduction and response. It suggests that this is a progressive development of international law, in that it adds that states shall not only cooperate among themselves, but to also rely on the assistance of various actors, for instance, such as the components of the Red Crescent and Red Cross and Red Crescent movement. And of course, having that caveat of as appropriate, meaning that the states are in control of how that cooperation will be received and managed. Of course, there are questions that come to mind. How do we cooperate? And what is the best way for each country? Is there an individual, a way of doing things, a universal way of doing things, or should they be catered to more individual country needs? Those, I think, are issues that can be fleshed out later in negotiations. And of course, we will probably most likely rely on the experts who know better about disaster responses, not only the lawyers that are present. Of course, this idea of duty to cooperate finds correlations in other fora too. For instance, I already mentioned the Sendai framework. In paragraph 19b, it indicates that disaster risk reduction requires that responsibilities be shared by central governments and relevant national authorities, sectors, and stakeholders. In paragraph 19d, it also indicates that disaster risk reduction requires an all of society engagement and partnership. So that idea of cooperation already is envisioned in the draft articles and correlates with many of the other regional frameworks that are out there. Another example that I think should really focus on is the developments within the Asian region, the ASEAN region, for example. ASEAN has a binding agreement, which is the ASEAN Agreement on Disaster Management and Emergency Response of 2005. In that agreement, there was established what's called an ASEAN Coordinating Center for Humanitarian Assistance on Disaster Management, or nicknamed AHA Center. These are some of the examples that regional cooperation can be used to foster a more better understanding of how to best handle disasters. And I think the draft articles, if they were going to go through a negotiation process to try to create an international convention, they can look towards the ASEAN region or other regions that have case examples that you can apply, and the lessons learned and the challenges that were faced in order to make the draft articles even more comprehensive. Another example that I want to raise is the cooperation that exists through the work of the ASEAN Disaster Preparedness Center, or ADPC. It is an international organization that supports global initiatives on climate and urban resilience and provides the effective humanitarian responses to disasters. The third issue, which is the obligations for disaster risk reduction, which is found in Article 9 of the draft articles. It is quite notable that it covers responsibilities of states in all stages of the disaster cycle, not only in its response when a disaster happens. This is also reflected again in the Sendai framework and acknowledges the role of disaster risk reduction in the protection of persons. The last issue that I want to raise is found in Articles 11 and 12. Article 11 talks about how it is a duty of the affected state to seek assistance, and to the extent that the disaster manifestly exceeds its national response capacity. Article 12 provides that states, United Nations, and other potential assisting actors may offer assistance to the affected state. So the wording is rather permissive, not mandatory in nature, and is definitely within the state to decide how to manage and accept that assistance. And briefly to the second question that was posed by the moderator, how to balance these responsibilities with sovereignty concerns. I think there is that careful balance. I think it was envisioned in the draft articles that this would be a major concern for states. So the draft articles do not invoke any state responsibility or impede on any state sovereignty issues, but in fact, they facilitate adequate and effective responses to disasters and risks of disasters. So the idea of the draft articles creating responsibilities for states is actually very well in line with sovereignty concerns, and they in fact go hand in hand quite well. Of course, the articles, we can find examples of this. For instance, in the preamble, it states that the draft articles reflect the fundamental importance of state sovereignty and non-intervention as a long-standing principle. Affected states, of course, are defined clearly, and they rely on the IFRC guidelines as the basis. Article 3 also says that there is no compulsory mechanism for international assistance that is provided through the draft articles, meaning that affected states and assisting states must cooperate and help each other through the idea of consent. And of course, any assistance provided, of course, is voluntary in nature. So I would like to just end that. I think that the draft articles are really a good basis in which states can come together and work on those as a overarching framework in which to discuss further how they can make use of these articles to craft a more universal, more uniform manner in which we can deal with disasters. And of course, these articles are, in fact, based on existing law. There is no new idea that has not been thought of before, and they have been drafted through a process of extensive research. So for Thailand, we're very happy to support the chair, Ambassador Antonio, in this year's UNGA, and we hope that the ILC articles will indeed form a basis for further discussions. Thank you very much.
Thank you, Director General Tang, for your invaluable insights and typically highlighting the strong emphasis that the draft articles place on human dignity and also the duty to cooperate, while providing some great examples from the region. But also, I think you noted the need for this to be also balanced and appropriate. I think also your point on the staggering of this process, that right now we're looking at a high-level treaty with the finer details to be ironed out later is also very important. So thank you. Just before I introduce our next panelists, I just want to remind those who are joining us that we have a question and answer function. So if there are questions that come up as our panelists are speaking, you can pop them in the Q&A chat, and we can get to that during that session. Our next panelist is also a representative from a state within Asia Pacific, but a state which also holds the characteristic of being a small island developing state, or SIDS, which account for almost 40% of all states in the Asia Pacific region. And I'm pleased to introduce Ms. Jeanette Vere, who is the Charge d'Affaires ad interim for the permanent mission of Tonga to the United Nations in New York. Ms. Vere, welcome. Small island developing states are often disproportionately vulnerable to natural hazards and climate impact. I would love to hear from you on how the draft articles address the unique vulnerabilities and challenges faced by SIDS and disaster preparedness, response and recovery, and also where do you see the role that the international community should play in supporting SIDS and implementing the draft articles, and how can partnerships between SIDS and international actors be strengthened to ensure effective implementation and resource mobilization? Thank you.
Thank you, Madam Moderator. My respect to the excellencies and distinguished colleagues. Before I respond to the questions posed, please allow me to convey the permanent mission of Tonga's gratitude to the International Federation of Red Cross for convening this critically important event. I'm pleased that His Excellency, the Ambassador of the Philippines to the United Nations, has comprehensively guided us through the chronological development of this process to date, and Dr. Tang, the Director General from the Ministry of Foreign Affairs of Thailand, shared critical views worth considering, noting that these draft articles are a good basis for us to work on. Tonga, like other small island developing states, is more often than not disproportionately vulnerable to the adverse impacts of natural disasters due to a myriad of factors. I would like, therefore, to first and foremost highlight the unique vulnerabilities and challenges faced by SIDS, specifically Pacific SIDS, by focusing on the following prior to addressing the questions posed. First of all, the geographical location. SIDS are often located in regions prone to hurricanes, cyclones, tsunamis, and other natural hazards. Their small size and dispersed populations can exacerbate the impact of disasters. The Pacific is particularly facing a different geographical challenge given their remoteness from the rest of the world. Tonga, for instance, a geographical, geological, and socio-economic context fundamentally determines the vulnerability to climate change and disaster impacts and risks. In accordance with the World Risk Report 2016, Tonga was ranked as the world's second most at-risk country to all disasters, including climate change-induced disasters and geological disasters. The Intergovernmental Panel on Climate Change predicts that the intensity and frequency of the climate change-induced natural disasters will continue to grow, increasing the possibility of countries experiencing large-scale disasters that will require them to turn to the international community for assistance in meeting the needs of the affected populations. Secondly, the economic fragility. SIDS economies are import-driven and are heavily reliant on the service sector due to their geographical remoteness and the size and undiversified structures of the economies. 13% of Pacific SIDS lies below 5 meters above sea level, and given they are natural disaster prone, the GDP of Pacific SIDS is approximately affected by about 2.1% every year from 1970 due to natural disasters. So disaster reconstruction requires massive resources, and SITs are reliant on external financial resources, which contain higher cost of borrowing. High freight rates increase imports and consumer prices, especially in SITs. Tonga witnessed, after the devastating Hunga Tonga Hunga Ha'apai volcanic eruption and the ensuing tsunami, how hard-won development gains were swept away almost within a blink of an eye. In fact, the losses incurred by the Tongan economy as a result of climate-related disasters alone have increased by almost 40%. Lastly, social factors. SITs may have limited infrastructure, healthcare facilities, and emergency response capacities. Small populations and remote locations can hinder effective disaster preparedness and response efforts. With regard to how the ILC draft articles address the unique vulnerabilities and challenges faced by SITs in disaster preparedness, response, and recovery, I must at the outset state that the Alliance of Small Island States, AOSIS, doesn't have a position on the draft articles. Different members have different positions. It appears that there are some general concerns, including, first and foremost, a clear definition as to what constitutes a disaster. Therefore, it might include disasters that are not truly natural, like ones that result from climate change. These disasters are caused by the inaction of other states and mitigation. But we would envisage an outcome that works collaboratively and in the support of SIT's efforts on other related processes, specifically those under climate change. The draft article should strengthen duty of cooperation so that states can provide assistance to affected states in disaster risk reduction, response, and recovery efforts, although noting the need to uphold state sovereignty in this regard. All actions taken in disaster response and recovery should respect and protect the dignity and rights of affected individuals. If I may continue on to touch upon the last question, I believe it's critically important that the draft articles ensure that special circumstances of SITs adopted in other related processes are harmonized and not undermined. And as such, we would envisage the process to recognize collaborative kind of strategy to ensure that the circumstances of SITs are properly reflected and dealt with. I think I will stop here, Madam Moderator, and happy to answer any questions later. Thank you.
Thank you for your platform and for highlighting some of the unique vulnerabilities and fragilities of small island developing states and the ways in which the draft articles can help to support to address these. I think one of the important points you also made was how key it is to ensure that this particular process enhances as well other existing ongoing processes rather than acting in competition of them. So thank you very much for your very important intervention. This brings me to our next panelist, Ms. Adelina Kamal, who is no stranger to the Asia Pacific region, having served as the former executive director of the ASEAN Centre for Humanitarian Assistance, more commonly known as the AHA Centre, which Director General Tang also spoke of earlier. Welcome, Ms. Kamal. I'm cognizant that although you are not speaking tonight on behalf of the ASEAN Secretariat or the AHA Centre, we do really value your extensive experience at the regional level, and we welcome your thoughts on what role do regional intergovernmental organisations play in enhancing coordination amongst member states and other stakeholders in disaster response and humanitarian assistance as outlined in the draft article? And how can regional intergovernmental organizations facilitate the harmonization of disaster response and protection standards across member states in line with the draft articles? Over to you.
Thank you very much. And thanks again for inviting me to participate in this high-level webinar. Greetings from Indonesia. Good evening. I would like to share my personal reflections on the draft articles in relation to the regional work and the context where I work with in the past, that is ASEAN. First, with regard to the potential global disaster treaty, I would say that ASEAN is ahead as it has adopted a regional treaty known as the ASEAN Agreement on Disaster Management and Emergency Response, as mentioned by Ambassador from Thailand earlier. In fact, some of the provisions set out in the draft articles or the potential global treaty are already covered under the regional agreement. And the regional agreement is much more comprehensive than the draft articles in many aspects. Not only that the regional agreement has been adopted and entered into force, it has been translated into field operations, allowing for collective response among the 10 countries of ASEAN, facilitated by the AHA Center, to not only one, but over 40 major disasters in the region, 40. The development of the regional agreement itself in 2004-2005, after the Indian Ocean tsunami, was inspired by the ASEAN countries' response and recovery efforts after the tsunami, but also informed by global soft instruments such as the Hyogo Framework for Action and the subsequent Sendai Framework, as well as the International Disaster Response Law Guidelines, which also have been used in the operationalization of the regional agreement. The regional agreement also covers all phases of disaster management, not only response, but also risk identification, early warning, prevention, mitigation, preparedness, response, recovery, rehabilitation. It also covers technical cooperation, and not only how the states of ASEAN offers and accept assistance, but also how the states of ASEAN are working together and working with the others, including the Red Cross and Red Crescent movement and the UN and the international organization. And not only that, the agreement has been translated into 5-year rolling work program, which has reached the 3rd cycle by now. So definitely regional treaties, as in the case of ASEAN, can inform and even further enhance and add realities to the development of the potential global disaster treaty. So that's my first point. Second, it is interesting to see that the draft article suggests for inclusion of human dignity and human rights for the protection of the people, because protection in times of disaster is part of human rights. This certainly can inform ASEAN's ongoing work on protection of people in the event of disasters. ASEAN recently adopted the ASEAN Regional Framework on Protection, Gender, and Inclusion in Disaster Management. And a technical working group has been formed to allow for those working in the disaster management to work more closely with those in charge of protection of women, children, and other vulnerable groups. And in fact, long before that, the AHA Center at the operational level and in practical manner already mainstream protection in the needs assessment tools, as well as in the provision of relief assistance. So in the case of ASEAN, there are this existing mechanism and ongoing work that can be utilized later on to further promote harmonization of disaster response and protection standards across countries in line with the draft articles, because we have actually been utilizing the, many of these principles, though using the soft instrument like the International Disaster Response Law guidelines. However, also based on my own experience, operational experience, facilitating collective response to the most catastrophic disasters in the region, it is also important to note that some states, not only in ASEAN but also beyond, may have reached certain capacity level internally, where external assistance should complement rather than substitute the capacity that already exists within the country. As in the case of Indonesia, the case of Philippines, and some other countries in the region, these states may have already developed their own disaster laws or disaster management bills that are much more comprehensive than the Global Disaster Treaty. So I think it's not only the regional treaty, but some of the disaster management bills already exist in countries that are prone to natural hazard-induced disaster can also be utilized in terms of their first-hand real experience. Now, having said that, here goes my other points. As a point of clarification, it is important to be clear if the draft articles only concern about natural hazard-induced disasters, or are we looking at the broader definition of disasters? For example, to include complex emergencies, disaster happening in conflict settings, or even in other types of disasters. Because in reality, the complexity of context where we operate has increased to include not only catastrophic and large-scale natural hazard-induced disasters in view of climate crisis, but also other types of crises, including pandemics, including technological failures, including conflicts. And this can often be intertwined. A case in point, as I was preparing for today's webinar, I observed that the Kachin state, as well as other townships in central Myanmar, with ongoing conflict, have been experiencing massive flooding. And last year, in 2023, Rakhine State experienced a devastating Cyclone Mocha, resulting in the unnecessary casualties, which could have been prevented. Because in fact, cyclone is trackable. We can actually see the movement of the cyclone using today's technology. As the potential global treaty will be state-centric, the feasibility of protecting the most affected and vulnerable people in the event of disaster in complex settings like in conflicts could be challenging, particularly if the so-called state is contested or not accepted by the majority of the population, or even does not have effective control in areas where the disaster occurred. It will be more problematic if the so-called state is considered by other states as entry point and the external assistance is subjected to their consent, because based on experience, aid can be manipulated and used as an advantage over other parties in conflict. So I think that clarity should be made here. And it is, while perhaps the tendency is to focus on natural hazard induced disaster, the reality that we have right now, we cannot actually separate responses if these are happening at the same time or one after another. I also see the need for those working, because we're talking about protection. Protection is part of the rights of the people, part of the human rights, right? So I also see the need for those working in the human rights and the disaster management fields to work more closely together, and that the right to protection should be advocated before disaster, not only after. And there shouldn't be a dichotomy between the two, as both champion the protection of the people. While convergence may be difficult, complementarities can be found to see to what degree humanitarians and disaster managers are upholding not only needs-based, but also right-based response. In fact, on the ground, again, based on experience, and in the case of frontline responders, such rigid sectorizations of human rights, humanitarianism, development does not exist, as everyone is trying their best to help the affected people. So those are some of my reflections, and I'm here to respond to any questions later on. Thank you.
Thank you very much, Ms. Kamal, for such a thought-provoking intervention, and for also reminding us that ASEAN is actually streets ahead with the ADMIR, an existing regional treaty which has been in place for some time and is working well. And I think this also emphasizes Director General Tang's point that nothing in the draft articles is actually new, but they already exist in various forms already around the world. And I think your point, especially on the scope of the draft articles to include complex emergencies, is also very interesting, and perhaps one of our panelists might be brave enough to take that up in the question and answer session. Our next panelist, Professor John Hopkins, is the Director of the New Zealand Institute of Law, Emergencies and Disasters, also known as LEAD, and he'll be sharing with us the very important perspective of academic and research institutions. Kia ora, Professor Hobb. Thank you for Hopkins. Thank you for joining us, and I do appreciate that it must be going on nearly 2 a.m. in the morning in New Zealand right now. So we really do appreciate you making time for us at this hour. If I could ask you to share your thoughts on how do the draft articles contribute to advancing international legal standards for the protection of persons in disasters, and what gaps or areas of improvement do you see in the draft articles from a particularly legal perspective? And how can academic programs and educational initiatives integrate the principles of the draft articles into curriculum development and capacity building efforts for future disaster management professionals? Over to you, Professor Hopkins.
Tēnā koutou, thank you very much for the introduction. Finau, it's a pleasure to be here, and even though it is 2 a.m. in Aotearoa, Christchurch, so I'll try and address those issues in my short talk. It's quite a lot to get through in a few minutes, so we can always come back to them in the questions. I suppose I'll start by saying that an admission that when the draft articles were first introduced or first produced in 2016, I actually didn't spend a lot of time thinking about them or focusing on them, because of the reality that many of you will know that the history of international disaster law is unfortunately littered with failures. There have been failed attempts at global treaties, failed attempts at organizations, which have all foundered usually on the realities of global politics. Now, in fact, as many of you know, although we've some recent but limited developments at the regional level, and some panelists, we've heard about ASEAN, and we could have talked about other parts of the world where you've had regional developments recently. Aside from the Tampere Convention on telecommunications and disasters and for relief operations, there are no other global disaster law treaties. That the Tampere Convention is the only one. And the reason, of course, is that states see security as the very essence of their core business, and have worked in this field and tried to understand it, and are reluctant to cooperate and accept international limits or obligations in fields, including disaster resilience and disaster law, because it's core to security of the person. Despite the obvious advantages that such cooperation brings, very few states have enough resources lying fallow to allow them to cope with a disaster. They're going to need help, but politics gets in the way. However, I've been proved wrong in this pessimism, and in fact, the draft articles that we're discussing today, thanks in no small part to a group of core states, many of whom in fact have been represented on this panel, have driven the process to a stage where a treaty is, I wouldn't say yet probable, but at least possible. And that's a significant advance that we should all take note of. What seems to have shifted the dial, I think, and we've heard a little bit about it from the other panelists, is the experiences of COVID most recently, where the interconnected reality of disasters and states, even developed states who found themselves struggling in the COVID period, it became obvious of the need for better cooperation. And then, of course, the increasing realization that climate change, as well as creating a medium to long-term existential threat to our world and our species and our societies, also creates a short-term risk to individual states and territories, with larger weather events, we've heard about that already, occurring in areas where human habitation is much more concentrated and less resilient. We've also seen that in other hazards such as forest fires. So because of this, if you'll pardon the pun, we've had something of a perfect storm, an aligning of the stars of international relations, which doesn't happen very often, whereby there's a real possibility of creating a series of hard law principles to underpin disaster law and pushing forward the draft articles. I have to say, I think this is an opportunity that may not come again for a very long time. So I hope that it is grasped. So you asked me the question of what difference would it make to move to a treaty, so to take the draft articles into a treaty. Well, that's a complex question. There's lots of elements to it. I won't have time to go through them all, but it certainly wouldn't change the world overnight. We've already heard a couple of comments about issues with the articles as they are. But I would say there's two fundamental sort of underpinning shifts that I think we would see in international disaster law. The first is that I think it would raise international disaster law to be seen as a sort of full member of the family of humanitarian and human rights laws that already exist. Currently, it's seen as something of the poor cousin of international humanitarian law, the laws of war, because of course IHL has the Geneva Conventions and other international treaties. This would, I think, raise it to at least be a more equal and be a clearer part of that system. Second, or alongside that system, sorry, it wouldn't be part of the IHL, it would be sit alongside it. Secondly, I think we would see the normalization of disaster risk as an international responsibility, founded upon what I think is really crucial in the draft article, which is Article 7, the duty to cooperate. I think that's the core. To me, this latter point will allow other treaties and softer instruments to, and again, we've heard this a little bit already, to fill in the gaps of any proposed treaty, which, as it stands, is very high level and envisaged very much as a framework. But I don't think that's a bad thing, because it can the draft articles, because of the way they're written, could provide for, and I'll give an example. Sorry, in Article 15, we'll see that the draft articles mention the affected state shall take necessary measures within national law to facilitate prompt and effective provision of external assistance. So that's a pretty broad statement. There is some examples given, but they're still pretty limited. But on the basis of that, for example, the IDRL International Disaster Response Law guidelines produced by the IFRC could provide a soft means whereby such hard responsibilities in the proposed treaty could be delivered by use of these soft principles. I think this example is particularly important in the Asia-Pacific region, where problems around inappropriate international assistance continue to plague disaster response. So to be clear, I think the draft articles are far from perfect. I think we could have a debate, and we've already heard some some discussion about elements that could be changed. So in a perfect world, I would also raise some issues about the definition of disasters as is used, and the previous speaker mentioned that. I'm not entirely comfortable with the definition used in the draft articles. It doesn't reflect academic views on disasters, and it doesn't truly reflect, I think, the complexity of the disaster today. But and I think also the duty to cooperate could be stronger. But I would tend to accentuate the positive here, because the creation of a formal set of requirements around state responsibilities is itself a major step change in the legal frameworks around disasters and would be a huge achievement in itself. Now, if the draft articles don't progress to the treaty stage, or at least not yet, I mean, I'm in favour and I hope that it does. We shouldn't forget that IDL and the draft articles have the ability to influence international disaster law now. They exist as a soft law, and people have said this already, accepted set of, in effect, global norms, and can be a framework in which to teach disaster law and show the accepted norms that underpin it. And I note that one of my colleagues has looked at the use of the human rights periodic reviews to deal with soft disaster law in the way that Sendai has been used, and I can see the draft articles potentially being used in a similar way. But either way, my earlier skepticism around the draft articles has clearly been proved wrong. The draft articles have the potential to fundamentally move attitudes towards natural hazards and embed the duty of states to assist, manage recovery, and reduce risk, which I think is another key element of the proposed treaty, among other things, in the international legal order. This, to me, is nothing less than essential in the current environment of growing vulnerability to natural hazards, and we should be very thankful that the draft articles provide a realistic vehicle for delivering such an essential requirement as we move into an uncertain future. Ka kite anō, thank you for your time, and I look forward to some questions.
Thank you so much, Professor Hopkins, for bringing your very frank academic perspectives to this forum. In particular, really interesting to hear how your thoughts on this particular process was quite pessimistic to start with, and how the elements of, I think, what you called a perfect storm have provided a shift of the dial where the adoption of a treaty is now possible. And I certainly agree with you in applauding the work of the core group of states in this area as well. And you've also noted a number of perhaps not shortcomings, but things that could possibly be strengthened, as were noted by a number of other speakers. So hopefully we'll get to those as well in the questions. Our final speaker is a well-known figure in the disaster risk reduction space across Asia Pacific, and I'm pleased to introduce Mr. Marco Toscano Rivalta, who is the Chief of the Regional Office for Asia and the Pacific of the United Nations Office for Disaster Risk Reduction, or the UNDRR, who is joining us from India tonight, where he's also chairing a conference, but has thankfully managed to find a corner to dial in, join us. So thank you for being with us, Mr. Toscano Rivalta. Now, you've been involved in this process for quite some time. Can you tell us how the draft articles complement existing international frameworks and guidelines on disaster risk reduction and humanitarian assistance, such as the Sendai Framework for Disaster Risk Reduction or the SPHERE standards? And looking ahead, what are the key priorities and recommendations for international organizations to strengthen their support for member states in implementing the draft articles and enhancing disaster resilience globally?
Thank you very much, Finau, for this introduction and for inviting me. In fact, it was too important a conversation to miss it. So I'm very glad, and also was very keen to be able to contribute to these important exchanges. At the outset, please let me recognize the work of the International Federation of the Red Cross disaster law. I think that some of the gaps that we are able to see today is precisely due to the work, the leading work of the International Federation of the Red Cross. And also, I would really like to thank you for organizing these and with the support of the government of the Philippines and the governments of Thailand. Apologies if I would like to say a few thank you, but I feel they're quite important. I wanted to express my appreciation also to the Philippines for the work, for the leading work in this area, but also for hosting the upcoming Asia Pacific Ministerial Conference, as also the permanent representative is indicated, which is going to happen in October. And I really hope that this meeting today does contribute to the further reflection at the ministerial conference, where we are going to further discuss these issues. And I would be remiss if I didn't recognize also the government of Thailand. It's great to share the screen also with Kuntang, because the leading role that Thailand has had in the adoption of the Sendai framework in 2015. And I must admit that I was quite impressed by the wealth of knowledge and ideas that have been shared by my fellow panelists. So it's actually quite a bit of a challenge for me to follow. But I'll try to share some reflections along the lines that you have asked me to reflect on, Finau. And let me start with some simple facts. Disaster risk and disasters are increasing instead of decreasing. And this is contrary to what we had agreed to in Sendai in 2015. And this, of course, has major humanitarian and development impact due to the losses of human lives, as well as the losses in economic and social terms. So something is fundamentally going wrong, and despite what we had agreed to do together. Second point that I want to make in this first set of reflection is the fact that the disasters and disaster risk know no borders. And there are often transboundary consequences, be they direct or indirect, due to the nature of our interconnected and increasingly so world. And also, disaster risk reduction practices are somehow uneven across the world, and this has implication of the effectiveness of the measures themselves that we can take collectively, but also as countries individually. So this is the first set of facts that I want to point to. The second point that I want to convey is maybe more from a legal perspective. And let me recall that there has been no conference really that does not highlight the need for stronger normative framework internationally and domestically to prevent the creation of new risk, reducing the existing risk. And this been the case in different wordings for over 50 years. So we have quite a consolidated practice, and also the distinguished representative of Thailand and other colleagues have pointed to. There's nothing really new in the draft article on certain elements, and there are some other important novelties that they are bringing. But I will elaborate on what they are in my views. And many numerous GA resolutions, just to say the least. But also we have seen ASEAN and other regional deliberations. Then I need to stress that also the midterm review of the Sendai framework, which was concluded in 2023, and basically concluded through a political declaration adopted by the General Assembly, also highlights such a needs. And here the permanent representative of the Philippines has recalled that specific wording. So I would say that at the moment, under international law, we have quite a significant gap, and there is no a general legal provision to reduce disaster risk. Whereas in various branches of international law, there are some provisions, they are not necessarily sufficient to cover the full scope of the action needed. some examples of these different branches of international law, as also some other friends and colleagues in the panel highlighted, is human rights law, is environmental law, and there are also some other specific fields like a nuclear accident in aviation, so waterways management, that all enshrines a principle of prevention. Let alone, of course, also the UN Charter in terms of the threats to peace and security. So the question of prevention is quite strongly enshrined in international law in different fields. And I would like to recall that maybe one of the most interesting articles and closer to what we are discussing now is Article 11 of the Convention of the Rights of Persons with Disability that speaks to the question of situation of risk. So that article is quite powerful, but even when I look at these sum total elements across different branches of international law, there is still something that is missing when it comes to disaster risk reduction. And this is what I feel that the draft articles are bringing to the fore. And I do believe that the draft articles as developed by the United Nations International Law Commissions, they do represent a very strong basis to strengthen disaster risk reduction's legal foundations, both internationally as well as domestically. And here, as also some other colleagues have done, I would like to stress the value of Article 9, that despite having almost 10 years, I would say that it's still very much vividly on point, and is absolutely, his content is absolutely critical nowadays, as well as its scope. And let me just say a couple of words about it, if I may. Article 9, it does contain a clear legal obligation to reduce disaster risk. And I think that here the element of clarity, and this is the beauty of simplicity of that article, is that in essence, it does complement everything else. So it's not a duplication. Here simplicity brings a complementarity. And clearly points to what needs to be done. And it also recognized that the necessity to discharge such obligation by adopting relevant normative measures in order to create an enabling environment where responsibilities and accountabilities are well defined. And this question of accountability is quite an important one. The measures indicated in its paragraph 2, while not being exhaustive in their nature, they're certainly instrumental and core to enact many other disaster risk reduction measures. So that's why you are asking me about recommendation moving forward. I think that what is enshrined in paragraph 2 of Article 9 is spot on. And in fact, this has been, I would say, further confirmed by the fact that the United Nations Secretary General has launched in 2022, this initiative of early warning for all. And we all know and we appreciate the value of early warning system from a humanitarian perspective because they save lives. But at the same time, we shouldn't underestimate the economic and social value in terms of protecting human and capital assets, which are really core and central to the development of our countries and communities. And then this aspect of focusing on the access to risk information, the dissemination of risk information, this is all still vital today. In fact, the conference where I'm here in India today, it is about science and technology, innovations and disaster risk reduction. Interestingly enough, we have been speaking about these issues and recognizing the important value that norms have in enhancing the operating environment, where also the public and the private sector really come working together. And in essence, basically, and I here coming to my third point is the fact that fundamentally with certainly some exceptions. So I don't want to be too tranchant, but I'm trying to be clear as much as I can. Fundamentally, with some exceptions, creating unmanaged and unmitigated disaster risk is still somehow legal. And this is a problem. And we can see the consequences of this in the fact that disasters and disaster risk are increasing. So whereas, and I'm touching upon also some of aspects of the questions, so whereas soft law instruments such as the Sendai framework provide a very good indication on the work to be done, yet, as demonstrated by the fact of the increasing disaster risk and disasters, the lack of a clear and dedicated legal instrument, or at least legal provisions in this area, are clearly hampering the efficient and effective action. And moreover, there is a clear need to enhance international cooperation to reduce disaster risk, and this is the beauty of the formulation of Article 7. Because, of course, cooperation here needs to be guided. And if I can take the lead from some of the comments made by my fellow panelists, which I very much appreciated. In fact, I very much echo the point that there is nothing really new, but some of the novelties that I've anticipated. I think that the draft articles and the soft law instrument like Sendai are quite important and an interesting combination, so that the hard law, the draft article, define what needs to be done in very simple terms, and that simple terms enable synergy with more articulated regional instruments like the ADMER, as our colleague that used to work for the Health Center has highlighted. And here also the point of, and I'm touching upon also some of the point that John has made on the what and the how and a realistic vehicle. This is what the draft article asks vis-a-vis the Sendai, with the Sendai framework implementation. And also, I very much appreciated the point made by the distinguished representative of Tonga. And in fact, the draft articles, they try to go beyond these somewhat fictitious distinctions between a natural and man-made hazard, because in reality, disasters are not natural. They are caused by some, not the hazard in and of itself, but the exposure and vulnerabilities upon which an hazard is. So there's a lot of man-made in all the disasters. So with this, I stop. And again, I would like to express my appreciation, and I very much look forward to the further discussions. Thank you.
Thank you very much, Marco, and my apologies there. I seem to have dropped out. But thank you very much for your intervention. And I think the thing that always stands out to me in terms of what you've said tonight, and also what I've heard you speak in other forums, is that at the moment, it is still legal for states to create risk or to not mitigate risk within their own countries and their borders. And when it's phrased that way, it almost seems astounding. And so the fact that these draft articles might be able to provide a way to support states to reduce risk within their borders, I think is would be absolutely wonderful if we can, if we're able to have them adopted. So thank you. And you also touched on a number of points that have been raised by our panelists. And I'm very conscious that I've been a terrible moderator, and we are so close to our end time. What I'm going to do is I'm going to invite everybody to please leave if you need to when we get close to the time. But some of the questions, now that we've come to our question and answer session, some of the questions are really interesting. And so oh goodness, and they're still coming. So, so I'll probably say that we won't get through all of the questions, but we certainly will give it a go, because I think some of these questions as well are linked or follow on from other questions. There is a question in here on the linkage between these draft articles and the Geneva Conventions, and I'll just address that super quick, because the Geneva Conventions, or the law of war, are a global binding treaty on the way that states engage with each other in war. And at the moment, as many of our speakers have said, there is no global binding treaty at the moment on disasters, apart from the Tampere Convention, which only deals with a very small, I think it's telecoms, in terms of disasters. So we don't have anything. And so this is essentially what many of our speakers have talked about in terms of filling a gap. So we have I think it's a very interesting question here on, do you think states are willing to cooperate to make the draft articles binding? And it's really dealing with the tensions between sovereignty and rules, which is also linked to another question, okay, which I can't find at the moment, but I thought there was a question here on multilateralism, and I think I can't see it at the moment, but perhaps I will hand this to I think I want it up. You're looking sheepish. Is that you're looking sheepish, Director General? Would you be able to have a go at this question on states? I think in your intervention you were quite optimistic on this, but also kind of balancing it with a little bit of reality. So
I will try to attempt it, but I did see Marco raise his hand. If he wants to attempt it first, I wouldn't mind. But let me have a go of it. I think the political will, I think, comes from the necessity of having a law. I think despite not having an international framework or normative rules, states do not wait for that process, and the Asian region, with ASEAN being at the forefront, as Ms. Adelina said, we're advanced. The need came from having to coordinate all the necessary people that are involved in providing that disaster. So I think coordination is really underrated in a way. People take it for granted, but then when a disaster strikes, people look left and right and they don't know what to do. Having a clear description of telling you, please turn right, please turn left, please close the door. Those things are really important when you're handling a situation when there is full chaos going on. And states really want to be told, you know, calm down, we will help you. And this is the message that states really require. And so the Asian region, seeing a need, got together and then created this agreement. It's something that ASEAN should be proud of. We don't have that many agreements that are binding. Most of them are really a lot of declarations, and they're not really ready to commit, even among only 10 states. But this is a sign that there was a need, and then we were able to overcome the sovereignty issues and then really focus on that cooperation and putting that into action. So I hope that answers the question. Thank you.
thank you so much. Did you have anything to add to that, Marco?
Simply that at the time of the negotiation of the Sendai framework, many delegations were coming up and asking why couldn't we do it as a legally binding agreement. I thought that was quite an interesting set of comments coming at that time. Of course, the process was not geared toward that, but the very same fact that many felt that during a formal process of negotiation, I thought that was quite indicative. Of course, now it's different days, but still, I think that feeling may not have disappeared. Of course, the important political considerations that Kuntang has just made.
Thank you, Marco. What I'm going to do now is I'm just going to read out the question, and you can put your hand up if you feel confident enough to answer, because going back and forth with these screens is a little bit tricky. So there's a question here on COVID experiences of states from 2016 to today, and really whether we think that the adoption of a convention should specifically speak to pathogens as a hazard and epidemics, pandemics as a disaster. I guess it's really talking to the definition of disasters. Marco, I can see that your hand is half up. So.
Simply to say that just now, Sendai Framework paragraph 15 includes epidemics. And this was at the time where also Ebola was raging and luckily did not become a pandemic. But I think that the concept is already there, so the answer would be yes.
Perfect, thank you. This is an interesting question on to what extent do the draft articles integrate human rights, and why do we need a new agreement instead of using human rights instruments? Do we have any takers? Thanks, John.
Well, I think Adelina was going to say. So you go, Adelina.
No, it could be you first. But okay, since I have been unmute, I would say that in the past decades, what I have seen, not necessarily in ASEAN, but globally, that when it comes to humanitarian assistance in the event of disasters, the focus has been more on how to deliver relief items, and the aspect of the peoples could be forgotten, because the logistic of getting assistance to the disaster zone itself is already challenging, and then there are also aspects of diplomacy and the approval that will have to be obtained, because countries or organizations cannot just show up in a country offering assistance without their consent. That will create another type of disaster. So the uniqueness of this draft article to me is its focus on protection of the people, on human dignity. Because when it comes to humanitarian assistance, it's about reducing the suffering, again, suffering related to the people, saving lives, again, the people, and protecting their dignity. And the provision of relief items and all the services provided by the humanitarians as well as the disaster managers are basically eventually intended to protect the people, right? So I think the beauty of the draft article is its focus on human dignity and the protection of the people. And not just staff. And I think that emphasis is important to me. In terms of human rights, I see that I could see that perhaps the word human rights itself could be daunting. But as a disaster manager myself, those on the ground often said to me that humanitarian assistance is also human rights. And we do have the right for protection. Even we, as the victims or those affected by the disasters, do not even have to ask for it. So that's where the human right comes into play. And it should not be considered as something daunting to be fulfilled. That's how I see it. And this is where I think that convergence, or rather complementarity, should be sought. And it will be very interesting in the discussion. I'm not sure whether it is already, I think it's already reflected in the commentaries and the reviews provided by Bartolini on how these draft articles relate to the other human rights instruments that are available.
Thanks, Adelina. Anything further to add, John?
I suppose just to say that so I think there's two elements then that Adelina touched on it. That the first thing is that human rights have a role to play in disasters. We know that already, particularly in Europe. There's been a big push towards the rights of individuals through the human rights treaties. But this does something different. Firstly, with it, Article 5 explicitly recognizes the role of human rights in disasters, which I think is important to make, because I think we sometimes get the feeling that some states may feel that actually in a disaster they're not so important. And having explicitly mentioned there is a clear sort of line in the sand. And then the thing I would say is that the reason that you need this is because, of course, as Adelina mentioned, much of the treaty deals with practicalities. Oh, sorry, not treaty, draft articles. It deals with practicalities about cooperation. It's actually to do with states' behavior, less to do with human rights. So it's so in some ways I feel the title of the draft articles is slightly misleading, because it's actually creating obligations on states, or not obligations, but maybe in some cases obligation to improve their behavior around disasters rather than necessarily specifically protect individuals.
Thanks for that, John.
Just a little bit, sorry, Fina.
Please go ahead.
On the human rights issue, I think even though human rights developed as a set of binding, covenants, and then the various different groupings, whether it be children, women, disabilities, and whatnot, human rights is now an overarching issue that has its place in every single issue that human rights, that international law will be developing in, whether it be the pandemics treaty that's going on in Geneva, whether it be the cyberspace, cybercrime. Human rights is part and parcel of how we advance international law. The human aspect will always be there. And I think these draft articles really put into context what it means to actually uphold and respect human rights. There's this idea of intersectionality, meaning that vulnerable groups in the situation of disasters will be affected differently than various other groups, that those vulnerabilities will be exacerbated in some way, and it will even further make them, their rights will be neglected in a way. So those are the things that I think complement each other in a way. So we're not really creating a new set, but we're really giving it a face, really giving it the context that human rights law needs. Thank you.
Thank you for that clarification. We have a question here on the responsibility of the state to consider healthcare issues of the population. Now, I'm assuming that this is healthcare issues during a disaster, and whether this has been considered in the draft articles. So this is open to... It's quite a difficult one, but there's surprisingly two questions on healthcare.
Well, I'll just say I don't think it's, sorry, I'm from my memory, which is poor these days. I don't think it's specifically addressed in the articles as they're currently written. Of course, other international, we do have, the Bangkok Principles that apply already, a soft law statement, so other issues would apply, but that specifically, I don't think healthcare is mentioned as part, but it would come under, for example, the responsibility there for humanitarian principles and so on. But others may have better memory than me.
I just want to add my voice that the draft articles just really talk about the relief at the onset of a disaster, the immediate medical concerns that are needed. But in terms of the reduction of risk, now healthcare might in fact have more of an impact. Depends on how far down or how well advanced your healthcare system is in preparing the population for an onset. I mean, if you have a strong healthcare regime in your country, perhaps you're better able to provide the relief that's needed. Do you have people on the ground who are ready to come in when there is need, or do you have a more centralized system? So those factors, I think, contribute to the risk reduction, which is, I think, an important point. And this is where we find, I guess, differences in countries of how well prepared they are, because we are in fact talking about the allocation of resources and the priorities that states give. So that is why we have different ways of addressing things. So it's really up to each country. Back again to the issue of sovereignty again. It's really up to each country to determine what their priorities are in this. Thank you.
Thanks so
Maybe
much.
I say just something, so just to follow on that I suppose that's the point. It's very much a framework, the draft articles. So clearly, lots of them would have a healthcare element, but it's just not specifically mentioned.
Lovely. Yeah, please go ahead, Marco.
If I may, if we look at simply Article 9 in the paragraph 2, where it speaks about risk assessment and dissemination of risk information, if we recall that risk is not hazard, risk is the results of hazard, exposure, and vulnerability. So, for instance, the question of health immediately would come out related to the question of vulnerabilities. The same is also for other, like lack of education and many other dimensions. And I also quite like the formulation of paragraph 1 of that article, because it does recognize that there are differential capacities across countries. So it's an obligation of conduct, it's not an obligation of result. And that allows that tailoring, if you wish, that is really necessary, and at the same time complemented by the duty to cooperate. So in a way, a limited capacity of one country would call into question the duty to cooperate, to support these countries with more limited capacities to manage disaster risk. And if I may add one small element now to the comments you've made right after when I finished, I would like to place emphasis on the fact that such a responsibility is not only on the states, because disaster risk is generated by many other actors within states and across states through the investments that are made. So here the duty of the state in particular would be to create that enabling environment where different stakeholders, they have clearly assigned responsibilities and accountabilities, so that I think is an important aspect. Otherwise, there is too high expectations on states, which would be somewhat unfair. But the way Article 9.1 is, 9 paragraph 1 is formulated, recognize the duties to be discharged through the formulation of appropriate and relevant normative frameworks, something that states can do.
Thank you so much, Marco. Look, in the interest of time, I will take 2 more questions, and then we will wrap up, because I'm conscious, John, that we're going on 3 o'clock for you. So one of the questions that we have is, how are the draft articles different from the widely recognized norm of the responsibility to protect, which was agreed upon by most UN member states during the 2005 World Summit?
Let me attempt it first. I think responsibility to protect is the other side of the coin of the humanitarian intervention, meaning that there are serious, egregious crimes that are happening in a particular country that violates, fundamental human rights. Then it is incumbent from other states to recognize this and then intervene in another country's sovereignty in order to stop those crimes from happening. I think that was the idea of humanitarian intervention many years back, but then it shifted towards the focus on states to be able to yes, monitor and sort of regulate themselves in terms of seeing that, you know, it is the responsibility of the state to make sure that these grievous crimes do not occur, and that, you know, the fundamental freedoms and rights that are inherent are respected in that way. So I think it comes from a different aspect of international law, from a more security side, but I think the responsibilities under the draft articles are more of a cooperative nature, and they move away from the very difficult issues. And that is why in Article 18, I wanted to mention earlier that it actually specifically mentions that if the case is happening in a conflict, an armed conflict area, international humanitarian law will apply there. And these draft articles do not apply to that conflict situation, because IHL is already quite developed in a way. There's a law of war, and then the law of protection of civilians, which is quite advanced. And then there are organizations such as the ICRC, IFRC, which is really working really hard to advance those already. So there's no need to duplicate the work that's being done there. Thank you.
Thank you so much, Director General. This will lead, and thank you also for touching on the IHL, because this also answers a number of the other questions in the chat on the Geneva Conventions and action or humanitarian action during times of war. The final question is really on the scope. So the question reads, you spoke about a simplified global treaty with scope for regional agreements to add detail. Is the idea that this global treaty, the draft articles, will essentially, or that the global treaty will essentially reflect the draft articles, or will it also include aspects of IDRL or international disaster response law, or the laws around international cooperation? And I think there was that was the question here. Is anyone open, game enough to have share some reflections on this question?
I would be open, if you repeat a little bit, because it was a bit broken from my side.
Oh, sorry. So this is really about whether the global treaty, which I'm assuming is the future document that we're hoping to get from a draft articles, whether it will reflect the draft articles and also include aspects of IDRL. Now, in my understanding, there are several aspects of IDRL already contained within the draft articles, but I just wanted to confirm that with you experts.
Yeah, no, I certainly concur with your reading, Finau. Some of the important elements that the IFRC and partners have developed over the years have been taken in the draft article. But also, as the Director General was mentioning earlier, this is a basis to start, and certainly there are some important updates that even from a disaster risk reduction perspective may be introduced, because again, I must confess that disaster risk reduction is a very fast evolving area of practice. So certainly, let me use this formula, when we get into the negotiations, so I'm giving hopeful thinking that is going to happen, a number of updates can be introduced across different aspects of the work. But at the same time, the foundations are quite strong, and some important elements of the RLs are indeed already there. But this is something that can be looked into the moment that we enter the negotiation. I think that now, at this stage, is more the merit whether there is an added value or not, and what that added value is. And I think that the beauty of the conversation of tonight has highlighted what that additional positive edge would be brought into the international law field, with positive repercussion on state practice and other stakeholders, because of this important aspect of the shared responsibility that the Director General brought in also in her presentation at the beginning.
Thank you so much, Marco. And unfortunately, we have come to the conclusion of our webinar today, and I'd really like to thank our distinguished panelists for your time, for being so generous with your time and supporting this webinar, despite the challenging time zones for some of you, and also to our audience for joining us. We really hope that you found today's webinar not only interesting, but also useful in aiding your understanding of the draft articles and why they're so important. And we've had such great and diverse and interesting perspectives that we've heard from the speakers, but also some really great discussion as well for the questions and answers. So I'm not going to take any longer here, except to say malo aupito and kopun ka, and thank you so much. Thank you for joining us.